on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area.
I do not identify. I identify as the beneficiary that is here to protect the Derek Stringer. I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. Good luck to you.
We're about to go to war.
Things get wild fast. Judge Urich doesn't play around. He's dealing with a sovereign citizen who's either pretending to be crazy or actually lost it. This guy's in court for 2 counts of public indecency. He was caught doing inappropriate stuff in a park. Tell me in the comments, do you think he's acting or is he really out his mind? And if you like videos like this, don't forget to like and subscribe. Let's get into it.
Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect the Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today.
He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family and house member impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying assault from 2019 out of Markwood Woods, which looks like it was deferred as assaulting a public officer or obstructing.
Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Given everything that's before the court at this time, the court will set bond in the amount of $50,000. Cash or surety, no 10% allowed at.
I gotta say, Judge Urich is amazing at handling people like this. Other judges get annoyed or waste time arguing, but he shuts it down fast. He calmly points out their contradictions, and it's honestly pretty funny. The $50,000 bond he gave is fair too. This guy has several felony charges and is still young. He shouldn't be out on the streets right now. Hopefully he changes his ways, but it's hard to tell. He might really be mentally unstable, or maybe he's just faking it. What do you guys think? Let's get back to it.
If Mr. Stringer wishes to bring various motions before the examining judge, and that could include a motion to modify his bond, that is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on with the, what is going on? Right now?
I'm sorry, sir?
I'm being charged. I'm being charged an entity that is.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
Did you catch that? He literally said, "We're about to go to war." That's one of the dumbest things you could ever say to a judge. If I were the judge, I'd have held him in contempt right away. Now we're moving into a second hearing, this time with a different judge who doesn't hold back at all. This one get intense. What did you think about the first hearing? Let's jump into the next one.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Deranged Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
A living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mont-Lewis, can you prepare an order for competency review?
I think this judge made the right call putting him through a competency review. If you didn't know, when defendant tries to fire their lawyer but might be mentally unstable, it creates a big problem. If they're not mentally fit, they can't defend themselves, and that could even lead to their case being dismissed. This guy thinks he's smart, but it's clear he's not all there. It just slows the court down and causes chaos. The judge explains that being competent means understanding what's happening in court and being able to help your lawyer. But this guy argues, saying his lawyer didn't talk to his father and that he wants him gone. 8T this point. It's obvious. He's not competent enough to handle this himself.